That's Kanovis J and Hajobe Jutale. They've been brought to court right now. As you can see, security is very tight. What's the meaning sequence?
And the Republic of Uganda, of these proceedings, the gain of the commercial project market, the notice number 86 of 2024. Uganda versus K1 Arab President, the President Captain James Kola, A2 Arab Office 098, and of the title is a list. A3 has prevailed Australia. A ruling of the court and the objection raised amend the charge sheet. On 13th January 2025, Colonel Raphael Mucha Council for the State applied to amend the charge sheet by adding Captain Dennis Ora as the third accused person and application was allowed. When it came to pre-taking, Council for Colonel Dr. Chizalesi, led by Martha Karua, Yasu Papu, and Ernest Kalivara, raised the following objections in back of his trial before this court. That this court has no territorial jurisdiction to entertain charges that were already committed outside Uganda. The charge sheet was effective because it was not in accordance with the UPDF Act. The mention in defense forces is not clear as to the defense forces were referred to. How the accused persons, but that how the accused person was brought before the court did not follow the due process of the law. Counsel cited this court, the case of Omar Awad Omar and 10 others versus the General Consolidated Constitutional Petition number 55 and 56, 2011, and submitted that the accused person was illegally brought here from Kenya to Uganda having been abducted. That section 208 and 209 of the UPDF Act that appears to grant the court jurisdiction contravenes Articles 79 and 159 of the Constitution. Counsel read that this court finds the meeting of objection and discharged the accused person. In reply, Councillor Raphael Mucha for the state submitted that jurisdiction is a creature of the statute and therefore section 208 the UPDF Act gives jurisdiction to this court to try the accused person. A council further submitted that the words defense forces are defined in the UPDF Act to mean Uganda People's Defense Forces, and therefore the submissions of council to the accused are misconceived and should be ignored by this court. A council further submitted that section 117 on aiding and abetting and H on being found in an unlawful possession of arms or ammunition brings the accused person before the jurisdiction of this court. Council further submitted that the accused person was brought lawfully through the memorandum of understanding between Kenya and Uganda on interstate arrangement on defense and security for offenders involved in committing suspected to have committed serious crimes like terrorism, among others. A council further submitted that the constitutional provisions cited in this matter are not applicable. That is Article 23, 28, Clause 7, 12, 126, 129, and 79. Council further submitted that there is no decrease in the charge sheet as alleged. In the rejoinder, counsel for the accused submitted that in the case of Omar Awad Omar, the Tanzanian case of Mataka versus R was distinguished. Counsel submitted that in a number of cases cited in Omar Awad above where there is evidence of abduction, then the court has no jurisdiction to try the accused person. Lastly, counsel retaliated earlier prayers that the court finds made in the objection raised and discharges the accused person. At this court, after listening to the submissions of both counsel for the accused and the state, considered the relevant laws relating to this application as deliberated on this application and finds as follows. One, that jurisdiction is a creature of statute and section 208 of the UPDF Act gives powers to this court to try any person who has committed an offense in Uganda and outside Uganda. Two, that there is no defect in the charge sheet because the truth is charged under Uganda law, under Ugandan law, the UPDF Act, which Act clearly defines the defense forces to mean Uganda People's Defense Forces. Three, on the submissions that the accused person was abducted and brought to Uganda without following due process of the law, this court finds that there is no extradition treaty between Uganda and Kenya that was breached. To the contrary, this court finds that the accused being brought to Uganda through a memorandum of understanding between Uganda and Kenya on defense and security for persons suspected to have committed serious crimes did not amount to abduction. This court has considered the consultations of the Constitutional Court in Omar and others which were cited by counsel for the accused from paragraph 25 on page 63 to page 74 of the judgment and entirely agrees with the court. On the submissions that section 208 and 209 of the UPDF Act that appears to grant this court jurisdiction on contravenes Articles 79 and 129 of the Constitution. This court finds that it is not true that through Section 208 of the UPF Act appears to grant jurisdiction, but actually gives jurisdiction to this court to try the accused person. Jurisdiction being a creature of the statute, and this court having addressed itself to the provision of Article 79 and 129 of the Constitution. This court finds the cited articles not applicable in this application and finds that this court has jurisdiction in the case. Accordingly, the objection raised are hereby dismissed and the accused person shall take plea. So, then at Makinde, this 14th of Jan, page 25, under my hand and see this court. About the rule,
Yes, Mr. Chairman. Mr. Chairman,
all done council advisor.
okay, we make a case for that particular matter, Mr. Chairman, before he comes in. So if there may be, Mr. Chairman, it's a matter of law, it's a matter which touches the Constitution. So we have to prepare to make Mr. Chairman.
And that's why this is my advisor. It's about law. Let him advise and then
Mr. Chairman, the issue is about making prayer for constitutional reforms. And we pray that will be permitted to do so, Mr. Chairman. And if it's a matter of constitution, it takes precedence over any other issue. And that's the reason we are seeking for your ears to permit us to make a case for a constitutional reference led by my colleague here, Council. That is our dream, Mr. Chairman. We make a case for constitutional reference. And if you do permit, Council Kalipara will proceed to take lead is in light of the ruling of the section. And I'd like to emphasize that where constitutional matters raised, it takes preference over any precedence level over any other matter. So, we beg that you permit us, Mr. Chairman, to proceed about the case of the constitutional reforms.
I have no problem with your submission, Council, but what I'm saying, he advises the court on law matters which you are going to raise. Finish the ruling, let him advise, and then you will be given time if it is allowed. I don't know what you are laughing. I don't understand what it means because
I think, sir, if he has any points based on the matters of law, the procedure is that you can adjourn your case, the state will respond, and this court will also rule on that matter, whether what you have raised requires a reference to the constitutional court or not. So you have proceed.
excuse me, I wanted just to know how are you laughing? Hold on. Unless you don't know his law, maybe he has advised. That's what I want. I think the council can say. I think about it.
Thank you, Mr. Chair. Honorable members. Following the ruling that has just been delivered, our instructions are to seek for the reference a number of matters. The ruling has itself interpreted articles of the Constitution and found them inapplicable. That role is a role that is reserved for only one court in this land, the Constitutional Court. Mr. Chairman, I want to preface my application for reference by taking the court to Article 208 of the Constitution. That article, Mr. Chairman, establishes the UPDF. It spells out a number of very good attributes for the UPDF: patriotic, professional, disciplined, and so on. Those attributes, in fact, distinguish the UPDF from other previous forces. So they are quite impressionable and quite useful. They are amazing attributes to have. I have found them also on the UPDF website. So the UPDF itself is aware of what these attributes are. One of the most important attributes in Article 208 is that the UPDF is subordinate to the civilian authority established under the Constitution. Mr. Chairman, what that means is simply that the force, its members, and its organs are all subordinate to civilian authority. In fact, the courts, referring to a number of cases, the courts have made pronouncements to that effect. We contend that in the finding that you have jurisdiction, this matter, General Court Martial is putting itself above civilian authority. I'll explain what that means. Mr. Chairman, our Constitution is a very, very important document to us. The preamble tells us all the things that were wrong in this country. It tells us the things we aspire to. And it also says these are the ideals we should pursue. And in saying so, it wasn't about 1995 when it was promulgated, but it was to continue up to eternity. That same document also gave us chapter 4, which covers many articles of human rights and so on. I'm going to refer to 28 shortly. But the force, the UPDF, must live by what the Constitution declares. In addition to what I have just said, that same Constitution says that the rights of all persons, including abused persons, are inherent, so they are not granted by anybody, not any organ, not any person. They are inherent. They can only be taken away in the manner that the Constitution has said they can be taken away. So I will start with Article 28, the right to a fair hearing. Honorable Chair, the right to a fair hearing has been described as that Article 28 as a culmination of Uganda's struggles against forces of tyranny, oppression, and exploitation, brought about unconstitutionality and political instability. It is one of those articles that cannot be derogated from. So there are no circumstances at all under which one can ignore or misapply or fail to observe that specific article. One of the most important aspects of that article is in Article 28:12. Article 28:12 provides, except for contempt of court, no person shall be convicted of a criminal offense unless the offense is defined, the penalty for it is prescribed by law. The emphasis is on the defined. What we are dealing with. So Article 28:12 requires that every offense is clear. The idea around definition is that when you read it, you know what conduct amounts to an offense and what conduct does not amount to an offense. And it cannot be derogated from. So if we have a situation where it's not clear, then we are derogating from Article 28:12.
So it's not character of individuals, it is the institution, Mr. Chair. Because I said military courts are not independent and that they are military courts of the executive, they belong to the executive. Moreover, the charges they try are brought by the army. And Mr. Chairman, the court made reference to two sets of people. Those who are not subject to military law, I suppose like me, and those who are subject to military law. I reckon, Mr. Chairman, like yourself, Mr. Chairman, and the officers before us, because they are soldiers serving, being a national duty of protecting our country. But he said that persons who are subject to military law, like every other person in this country, enjoy fundamental rights which may only be limited to the manner allowed by the Constitution. He said that judges of independent courts cannot be under the administrative control of the authority that brings the charges. In this case, my Lord, the Chairman, rather, we extend that the court is of the institution of the UPDF, and the offense that has come, one of which is to compromise the security of the UPDF. Again, it shows that the institution which placed all these gallant officers in their offices with the executive is complaining before them. Put simply, because Mr. Chairman, I'm a parent, I have a grown-up child, and I am offended by my neighbor, Mr. Kalibala, and I constitute a panel of my children to try the matter where Mr. Kalibala is accused, and I am the complainant. The likelihood that my children will find against me when I buy their clothes, uniform, when I pay their salaries, is unlikely. But more important, in the eyes of Mr. Karibala, he's not likely to see that as a fair process. Because after all, the person charging him is one who I can direct to attend to me by instruction. And they must attend to me whether they want it or not. Because as officers, you answer to the high office. Mr. Chairman, in that respect, the courts have taken note of individuals who are subject to this law and said that officers and militants of the Uganda People's Defense Forces do not, by joining the UPDF, surrender their rights and freedoms on account of joining the UPDF. We are thankful that today we have name tags. If I turn around, I can see Mr. Wanimbwa. He doesn't surrender his rights because he has joined national service in terms of the UPDF. He enjoys the same rights as I enjoy. So if in one dispensation, I am entitled to a fair and unbiased court, we are the same, all of us wearing the same image, and therefore he is entitled to the rights and enjoy. So the courts have said that such rights and freedoms are available to the officers and the militants of the UPDF because they are available to all the other Ugandans who live in this country because they are inherited. The other point, Mr. Chair, my colleague referred to Article 137(5)(b) of the Constitution. He alluded to a question which the court comes across and a question which is a request by the party. To be certain, Mr. Chairman, in this case, it is the accused persons from the amended charge A2 and A3 who, through their counsel, are making this request. In that regard, the Constitution, which my colleague has repeated many times, is superior to the gallant force of the UPDF, commands all courts, including this one, to frame a question and forward it to the Constitutional Court. It does not allow this court the opportunity to determine whether there is sense in raising that question, because that is not its duty. To determine, upon response from our colleagues, that we can examine the validity of that question, or if in their view, question has been had before, is to defeat the Constitution. Mr. Chairman, Article 3 of our Constitution says that anyone who acts in breach of the Constitution creates a very big offense, which perhaps, again referring to Mr. Wanimbwa here, will now bring him under this court, it is treason. So, we are urging the court, Mr. Chairman, that once we raise the questions that we have done, the honor or the duty of this court is to put the question in proper wording and send them up, and not to determine whether the questions should be sent, because the duty has been done already. There has been a request. Mr. Karibala also referred to the Enforcement Act of Human Rights and said derogating from a non-derogable right, Mr. Chairman, is an offense.
In emphasizing the point Fred Mpanga has raised of Article 3, any attempt by this General Court Martial to proceed with the prosecution in total disregard of this finding of the Constitutional Court, with all due respect to the General Court Martial, it will be treason. It will amount to treason for this General Court Martial to proceed with the prosecution, with the hearing of the matter, in total disregard of this, because the Constitution Article 3 is very, very clear on the observance of the constitutional order, respect to the given constitutional order and the interpretations given. So I urge you, Mr. Chairman, members of the panel, not to commit treason by proceeding with this matter. Now, Mr. Chairman, with your permission, I beg to move and frame 3 issues. The first issue, in addition to the first one is about the propriety of the proceedings, the charge sheet canvassing, Mr. Chairman, whether the trial premised on arrest and rendition of accused persons from Kenya in total disregard of the extradition law and other international laws, and on the basis of a memorandum of understanding which is not within the framework of the extradition laws, amounts to a violation of Article 28 of the Constitution. Mr. Chairman, in your finding this morning, you indicated that there is an MOU between the government of Uganda and Kenya to exchange people presumed to have committed offenses, which obviously is not premised on international law or the existing extradition acts or laws of both countries. So that is a matter which requires constitutional interpretation. Can there exist an extradition treaty outside? No, not a treaty, an MOU. Yet the law provides for an extradition treaty. And isn't that a violation of Article 28 of the Constitution, which guarantees the right to fair hearing and other relevant provisions?
Omusumba ye n'asaba n'agamba bagawugule gagende wakumuluma 13
era mbyagalira ddala pulezidenti wange
betwasaba bajje batusabire tebakoze eki tebalabise
tugenda kwekalakasa paka kulya